conference being held for the first time in the foodie paradise of Austin, Texas. If you don't take some time while you're here to go and check out the restaurants outside this hotel, you are missing a world of pleasure. So please go eat out. The hotel food's great, but go try someplace outside. This town is amazing for food. This is the keynote hall, and this expert panel session is Your Portfolio Never Dies, Estate Planning for Domain Investors. I'm Bill Sweetman, president of Name Ninja, and it's my honor to introduce the moderator of this session. But before I do that, please make sure your smartphones, tablets, and chatbots are in silent or vibrate mode. Thank you very much. Now, let's meet our moderator. Derek Newman is a domain name lawyer with 20 years of experience. And if Derek looks familiar to you, it's because he has moderated panels at many domain conferences, including this one, NamesCon, since its very first year. So please join me in saying hello to your moderator, Derek Newman, partner at Newman Doors. Derek, take it away, Bill.
Good morning, I'm Derek Newman. I'm a domain name lawyer. And this could be the very most important panel that you come to, because it is here that you're going to learn how to hold on to your domain names after you die. You thought this wasn't a big deal, but you're going to hear from some gentlemen here on this stage that are going to explain why. If you have domain names, you must have an estate plan in place. And if you don't, your heirs could lose everything that you have generated that they should have the benefit of. So let me introduce to you our panel. Everybody knows Ari Goldberg. He is perhaps the most famous domain name lawyer. He has a business called domainsforsale.com. That's a great domain name. And he helps with that business sell domain names as a broker in a kind of boutique way. He's going to explain what connection that has to your portfolio and protecting it after death. This is Mike Robertson. You know him too. He's at fabulous.com. He's the director of business development. And the interesting thing about Mike is going to tell you a story. He was at fabulous.com during the first iteration, because there's a second. And he was up all night for like 3 days dealing with somebody who lost domain names after death. He's going to tell you that story. He's like, wow, this is a big deal. So he left Fabulous. He started domainguardian.com. It didn't take off, which is just surprising because people did not understand what we're talking about here. He's going to tell you about this. This is Mike Gargiulo. Mike Gargiulo owns VPN.com. He bought that name for $1 million. He uses that for lead generation. He's made many millions since then on that name. And he too is a broker. He has helped people who have lost domain names after death. He's going to tell the story. And then finally, Manish Dayal is a lawyer in Los Angeles. He has a lot of domain name clients. He too has a great story. I would like to start with Mike Robertson, because Mike perhaps has the most compelling story because he was up all night for minutes. So why don't you tell us what happened there about domain guardians and what the folks in this room should do?
Thanks, Derek. So I was with Fabulous for 9 years. We're dealing with a lot of major portfolio owners who had some pretty good domains. Logging into my emails one Sunday night just to check in on things, and had an email from someone I didn't really recognize. Turned out it was the wife of one of the customers that I dealt with on a day-to-day basis, and a very panicked email. My husband has passed away. I'm the widow. His domains I'm supposed to transfer to me, and they're gone. And in me, panic mode, what is going on? So I log into the account, I can see some very premium, high value domains are missing, and just trying to track down where they have gone to. Transferred to DirectNick, another registrar that I'm very familiar with because I'm with them now. And because I have a lot of good relationships with the other registrar, I contact Michael Ward and say, look, there's this instance, I haven't got to the bottom of it yet, can you put a hold on this account for me, just until we figure things out. So long story short, verified that the husband had passed away, she was the next of kin, and what had happened was the husband's brother was gained access to the account and was moving them away without her permission, changing name servers, changing monetization, and basically feeding these domains. So we got all the legalities out of the way, and then it was the process of moving everything from Directive back to Fabulous, back onto the correct name service, keeping the status quo. A very tense 3 days, but a very rewarding.
And we're going to get to how you started domain guardians after that.
Correct.
But, Manoush, did I pronounce that right? Manish, I'm so sorry about that. So you're a lawyer, and you actually had a case where there were fiduciaries, like lawyers or accountants who stole the decedent's names. Can you tell about that?
Yeah, sure. So I represent a couple different domain partner companies. Most prominent is Botus. I can't comment on the total details of this case because some of it is still in active litigation. But basically, one thing that is critical as a domainer when you're developing your estate plan, whether you go by way of a will, which I don't really recommend, you should try to set up a trust, your Vigos trust, so you can determine who's going to get your domain names after you pass. It's critical to select the right trustee, someone that you normally would trust, whether it's a private individual or an institution that will assign you a trustee, whether it's a trust company or a bank. The reason why is, in this case, that we got drawn into sort of active litigation on. What happened was the domainer who trusted their attorneys and the fiduciary people that had fiduciary duty to them, there's a number of disputes over who ultimately got the ownership. And what ended up happening was there's a dispute over attorney's fees, and some of these attorneys actually had to take these domains back as repayment. That it's less about the details of that case, and more about it's critical to not only select someone that you trust, but also try to foresee what's going to happen in the future. It's not just about developing an estate plan, it's also about surrounding yourself with the right people, beyond people that you can trust, but having an actual executable plan so that they can stick to the plan, there's no disputes. Because once you get drawn into litigation, as many of you know, it's basically a nightmare. Like litigation is a king's game where people can't really afford the fees. And it's something you should try to avoid at all costs. And in the sphere of trusts and estates, it's most likely entirely avoidable. So that's, if you take 1 point away, definitely don't forget about your estate plan. And it's not that hard. People just try to pull the wool if they're organized. But if you do just even a couple hours worth of research, it can be very easy to set up. There's numerous internet services, not just Domain Guardian. Willing.com is one of them. But all of those things are critical.
Michael Gargiulo, you've had some experience with people you've worked with after death. Tell us about one.
Yeah, no, I mean, I think there's a lot of risks that we're going to get to unpack today. I think death certainly is probably a bigger one. I think this industry as a whole is just, the good names are held by people who are getting older. This is something that I think collectively a lot of premium owners are thinking about more and more. There's a lot of, divorce, prenuptial agreements, taxation, death. How do all of these things happen? You yourself are not controlling your portfolio anymore. Most people, does a secondary person have access to your, who is, address? If they don't, how does expiry work when you're not here? How does litigation work when you're served on a name? How do these things impact a portfolio when you yourself are not, driving the car around? But no, as far as death and divorce, there's one situation right now, two situations right now where we're working through on a deal, and they're basically held up because one was in probate for 3 years, so there wasn't a proper will set up or a trust, as we just heard, set up. Unfortunately, the widow, the surviving person, is struggling. Fran, I'm going to just touch on you for a moment. Fran has experienced this for the last 4 years. Her portfolio went through a death, and she has spent the last 4 years getting it back. So even something as simple as a will or a trust can drag your portfolio through the absolute mud. So that's.
Didn't you say that you worked with somebody who had $7 to $10 million worth of domains, and they were locked at GoDaddy, and that was as a result of not papering it properly?
Yeah, there's domain disputes that come up that might not necessarily be litigation or a UDRP, but there's what's called registrar locks. Your registrar can put a lock on a domain for any reason it feels compelled to. GoDaddy has its standards and policies. Fabulous has its standards and policies on what they might trigger a registrar lock on, but that's an unforeseen risk. There's a gentleman and client that we're working with now, an $800,000 transaction is at a complete standstill. And we're at a GoDaddy conference, so it's certainly, there's nothing at the registrar level that I can speak to there, but domain disputes are very difficult. There's not a lot of documentation. How do we handle that? How do we handle that when the court's in India and your documents are in Hindi? How do your portfolio treat these when you have to get a lawyer, you have to get documents translated? So there's a lot of risk that kind of goes into owning a lot of good names for a very long time, not just the 20, 30, 40 years that an individual like one of us might experience.
And so, Ari, there's really 3 times when you should start thinking about hiring a lawyer like you. There's your life, there's divorce, there's death. So in each of those 3 circumstances, what is your general advice for our friends who are wondering how they can avoid becoming that person who's tied up for 4 years or loses their entire investment?
It's the same thing. You want to have a plan. What I'm going to call a domain name continuity directive that has a life of all of its own. So if something happens to you, your domains are kind of running on autopilot. You want to have continuity in the event of death or incapacitations. That's one of the first concerns. We'll start a little backwards. At least that's the way I did my outline. So, as other gentlemen mentioned, you want to have a will and you want to put your domain names in the will. Of course, specify who inherits the domains, and that's really important for tax purposes. But you want to have a fiduciary, as Manish said. It's important because you need someone that is trustworthy. And it's an unfortunate situation in the case you had. It was a lawyer who was, breaching a fiduciary trust. But, the good news is that just because that person is a lawyer, they're held to a much higher standard than any other individual would. So if you're just, say, getting a friend or a colleague, watch out for my names in case I die, this is the person I want to have handle this, or if it's the executor of the will. These people may not have the same fiduciary obligations that a lawyer has, and certainly lawyers are governed by rules of professional conduct that are enforced by the Supreme Court, the state in which they're a bar. So it's really a good idea to use a lawyer, not necessarily me. There's plenty of good lawyers out there. I would recommend, however, that lawyer has some experience.
You do provide that service, right?
Yeah, absolutely. Yeah, we provide that service. We're concerned about our own domain names. One of my clients does own death.com, by the way. So, and we've come across, these situations where people have died and they've had issues. And it's important to have this continuity plan because let's say your heir is your child or your spouse. They may be completely unsophisticated about domains. And then they may go look out for people in the industry who some of them will be more than willing to help themselves to those domain names potentially. So that's, and I basically would say this, and I would say this if I weren't a lawyer, is that you really can't trust anyone because you don't know who you're dealing with in the future, what the situation is, and everybody, and if you're dealing with a domainer, there's obviously an inherent conflict of interest. This person's going to help you, maybe they're going to sell it for you, and that's why it's good to have a lawyer. And it's also good to have someone that's a trustworthy colleague or friend that understands domain names as well. Your domain continuity directive, this plan, can specify how your names could be sold in the event of some type of your death. You can select different brokering services or institutions like GoDaddy or Sato or whomever, and more than one because they may not all be in business if such a time comes along. Point that I forgot, maybe it'll come back.
We'll get there.
Yeah. So anyway, do you want to stop right now? Or you want to keep going? So that was death. The important thing.
You're on the clock.
The important thing is that when you die, this is a very interesting thing for domainers to understand, especially Francine, she said that you had an issue with getting names back. When domain names are held by one person and bequeathed to another person, there's a very interesting thing that happens with the value of those domain names for tax purposes. Domains are capital assets, most of you know that. You sell a domain name, at least in the US, you're taxed under capital gains taxes, and what are you taxed on? You're taxed on whatever you pay for that domain name, the difference between you pay for it and what you sell it for. Capital gains tax runs around 20%, it depends on your tax bracket. But what's real interesting is once the person passes away and leaves those domain names to another person, something magically happens in the tax code. It's called step up of basis. And what happens is the value of that domain name is now raised up to the market value. There's no tax, there's no estate tax on that. There have been limits up to the first $500,000, but generally there's no estate tax on getting that domain name. So the person who inherits that may inherit a domain name that cost them registering if they were an early, an OG, or the OG domainers. Some of them are in this room right now. They registered a domain name for $10. That name is now worth $1 million, right? And they sell it for $1 million. So if you get a market valuation that when you inherited that name it was worth $1 million, your heir will take that, will get that stepped up basis and sell it for $1 million and have zero taxes on that sale. So that's something, I'm just throwing that out there. I'm not an accountant, I'm not a tax accountant, so don't rely on that advice, but run that question by your accountant, just to be sure. So your name should be in a trust, and you should specify maybe how they're monetized, or you don't want to have them monetized. You want them to be used in a certain way, maybe for charitable purpose, or not used in a certain way. And I'll give you two quick examples. I have another name, it's Jewish.com. I want that name, I'm not going to go sell that name to any Tom, Dick, and Harry. You know, we got a lot of anti-Semitism out there. Next thing you know, you type in Jewish.com, it's going to have a swastika on it. My parents are Holocaust survivors, so that's really important to me. At the same time, I have a couple of really important names that are entrusted to me, not to be used or not to be sold. Hitler.com, Nazi.com, and Holocaust.org might be used for something. But you may want to specify that these domain names are not to be sold to, not to be sold, or you specify maybe they're not going to be sold to Steve Sachs over here, something like that, just to put it something. Or that they would be. Renewal and email management is really, really important. The domain name that's associated with all of your accounts, your administrative contact, that domain name that's at that email address must be a very good email address. It must be secure. If it's one of your own domain names, better make sure it's on auto-renew along with all of your other domain names. It's not even a bad idea to renew them for like 5 or 10 years so that in case there's any price increases or whatever, you're covered. Autopilot. Maybe Gmail address could be good. Just make sure that it's active and it's accurate. It's going to be needed by people that are there beyond your passing for inquiries. For renewal notices and for legal claims and for purchase inquiries. Make sure there's a good personal email address. All these things should be in your domain continuity directive. Now, another time to think about your domains is when you get married. If you happen to have a great portfolio before you get married, you want to have a prenup. That's critical. You may want to specify that domain names are they're not in marriage. Whatever, and it's important because that's going to be very important if you happen to get divorced, as I did 6 years ago. And I was lucky; we worked out a good deal. I got to keep the domain names, which was really good because I understand the domain names. At the same time, when the domain names are sold, my ex-wife gets a percentage of the domain names. And there are other domain names in there that there's specific, there were specific instructions with. But that's something that happens that we did after the divorce. It's also maybe an idea if before you get married, if those domain names are held in a business, so they're not part of the marital estate potentially. Again, I'm not a divorce lawyer. It's something we'll talk about with a divorce lawyer at that time, I guess, or whoever is helping you with your prenup. You may also want to split the domains with your ex, but it's important to have those considerations. And I'm finishing up now with it's important that you use a domain name continuity service like this one. This domain guardian doesn't exist. It should be bonded. It should have good management. It should be. They should respond to claims on your behalf, and handle the issues for you upon your death. Answer all the different statements.
You can break.
Mike Robertson.
Well, yeah. Yes.
Tell us about what led you to start Domain Guardians, why did you quite succeed, and what you recommend.
Yep.
That might be in addition to what Ari recommended for the people in this room and their portfolios.
Yep. So basically the situation that I explained earlier on was one of the, I guess, catalysts for thinking about offering such a service. There were a few other domain instances that I occurred during my time at Fabulous, discussions I had with certain clients, and came up with the thought process that, hey, this is a very real need, a service to be put in front of domain investors, because it's something that, one, they're not thinking about at the moment, but two, it's a very real issue that they should be thinking about, and how can we solve that? Went to market, and for whatever reason did not receive the uptick that, or level of support that we needed to continue that service, which is unfortunate, but also probably ahead of its time. There weren't really many known domains that had passed away to use as a case study, I guess. So again, that since we ceased operations on that, there have been some notable domain investors that have passed away, and it has got a little bit messy. But yeah, ahead of the time, also very difficult to price as well. It's always something, yeah, we want to use this service, but what are you charging? How do we do this? Again, it's just a new service. How do you market that? How do you price it? Just one of those stumbling blocks. But again, I do think it's a very real issue and a problem that hasn't been solved just yet. Hopefully in the future. Some things that I would put in place if I was a domain investor myself would be consolidate with very few registrars, just so you don't have them scattered everywhere, because when it comes time, your next of kin is going to have to manage these domains. Make it easy for them. And then on that point, have a very good relationship with your account rep at the registrar. Introduce your next of kin to your account rep, just so they know when that time comes, my wife.
Tell us about the Fabulous Executive Program.
Yeah, also we have, at Fabulous, we have an executive lock. This is a lock that is designed for your very high premium domains that you know you're going to hold on to them forever, or until you get a $1 trillion offer. So what we do is the customer can put an e-lock on the domain with specific requirements or constraints. So lock this domain, only unlock it if Steve Sachs comes to me and quotes, your portfolio never dies, 007. Something like that. So while the domain is on e-lock, it cannot be changed or altered in any way. It can't be unlocked to get an EPP code, you can't change the name servers, you can't change the whois. The only person that can remove that lock is someone at Fabulous. So a very important service that we do offer, free service, but it's only designed for those high premium domains.
Michael, what advice do you have to offer in addition to those?
No, I thought that was great. Ari definitely got the legal side covered. The only two things I guess I could really add to that would be more on the taxation side, and I don't think a lot of people get this right when they're living. Here in the U.S., if you're a U.S. business or a U.S. citizen, you can depreciate your name. It's a tangible property, Schedule 197. Just Google IRS domain depreciation, and the schedule will come up. Give that to your CPA. You can amortize it over 15 years. So if you have a cost basis, people who bought names in the auction last night, ad.com, they have really 7% of that cost basis each year they can take on depreciation. So there's one aspect of taxation that I don't think people get right when they're living, and depending on where you die, your domains are treated differently from the state standpoint. So different countries have different probate processes, taxation processes. If the domains are kept in a business, this is one of the unique benefits of that. You can, you don't necessarily have to go through the transfer process. Your survivor will still be a partner in the business. Their equity would obviously be probated, but the domain is not being sloshed around. And then, Schedule 179 in the IRS. Just Google this as well. It spells out how recent recently Trump altered the tax code to allow for full depreciation of particular assets. If you're a business owner, domains certainly are intangible property, but take a look at 179 as well. You can fully depreciate a lot of other items that you acquire for your business. That schedule is only active for the next 2 years, at least with the way the law is looked at now. So I would take a look at those. Again, consult your CPA. The IRS makes it pretty clear. They actually released a memo that spells how they treat domain names. Yeah, it's well worth a read. It's a little jargony, but again, just Google that. The memo is the first thing that comes up from irs.gov. And yeah, I do think having that continuity plan, making it as easy as possible for your next person. I personally have all of my email, my passwords, critical domain access information in a lockbox at a place where other people in my family, trusted circle, can access should something happen to me. That is not most people. That wasn't me for a long time until I really had anything of value. So just as you grow, there's a lot of value sitting here in this room. There's a lot of domains controlled by the people in this room. It's something to think about. Depending on where you're at, taxation, the treatment of that, especially after you die, from start all the way through to finish. You passing on and portfolio still living.
Do we have questions for the panel?
Yes, John, please start.
Pardon?
I said, uh-oh.
Yeah.
Oh, no, I have extremely few clients whose domain names are registered to them personally. Most of my clients have a corporation or an LLC, which is the owner of their domain names. So, talking about your portfolio never dies. Your LLC or your corporation doesn't die either. And if my domain names are registered to John's Domain Names Corporation, a Delaware corporation, then running into a registrar with, John Durryhill's last will and testament about his domain names, it makes absolutely zero sense whatsoever. So, to be clear, much of the points that were addressed here, only deal with the situation where you have your domain names registered to you personally. If your domain names are registered to your corporation isn't dying and doesn't have a will. Now, how you deal with the transfer of ownership of the corporation on your death is one thing, but you certainly don't want to have your domains registered to your personal corporation or LLC, and then your personal will saying, oh, well, I leave these domains to someone else because they're not yours to begin with.
Excellent point, John.
That's a good point.
So, Manish, Ari talked about a trust.
Yeah.
The great John Berryhill talked about putting into a corporation or LLC.
Yeah.
What would your advice be to clients?
Yeah, I think it really depends on what you personally would like to do. You kind of know the advantages of putting it into a corporation or LLC, but I actually wanted to back up and take an even 10,000-foot view and kind of explain better more specifically what we've been talking about, right? So let's just think about this analytically, right? If you die with no plan, right, that's called dying intestate. And in the US at least, there are a bunch of intestacy laws to sort of figure out what happens to your assets after your death. And these things are ancient. I mean, literally when you're in law school, in your second or third year taking these miserable trusted estates classes, you have to memorize bloodlines, like to your wife or your spouse, and then to your children, and then your cousin, and then yada yada yada, all the way down the line, right? So you want to avoid intestacy, right? That's the whole point of estate planning, is to get away from the state's default rules, because one dirty sort of problem with intestacy is if the state can't locate your heirs, then there's this process called escheat, where the state gets your assets. So I don't think anyone in this room wants to hand over their domains to a government entity if that can be avoided, right? So you want to avoid intestacy, just know. All right. So let's say you're going to develop your estate plan. So then you've got a couple choices. As Ari gives some excellent practice-oriented advice, domain continuity plan. What does that really mean? That means you're going to set up a directive, hopefully through the use of a trust, or if necessary, a will, on what to do with your assets. But what are the advantages of using a trust versus using a will? Well, one critical thing to know is wills have to get probated, right? So most people are familiar with courts from, TV shows. You go in, LA Law or whatever. I live in Los Angeles, and you see these lawyers fighting out in court. Probate is a specialized court process. It's not even a normal court, right? So if you have a will, now you got to hire a lawyer that's experienced in dealing with the probate courts, or if necessary, probate litigation, right? And the average cost to get something probated, to get a will probated, it's going to drain about 10% of your estate, right? So again, those costs can be avoided, because what's happening here is you go to probate court, now the court's got to figure out what your will means, right? This judge has to sit there and be like, oh, the last will and testament of, so-and-so person, this is what it actually means, and these are where your assets are going to go. But you can avoid probate, right? You want to make it easy. I think one theme that's been running through this panel is try to make it easy. Get your advice ahead of time on what you personally want to do. If you use a trust, as kind of Ari's advocated, right, and we've sort of advocated, you can set up specific directives of what to do so that there's no ambiguity. And as long as you nominate the right people to execute that trust as a trustee, you can avoid a lot of this misery that will be foisted upon your heirs. And that's critical. Another really big point that I mentioned is kind of, we had a question or a commenter is, work with your registrars, but also work with your partner company. Like if you're working with a monetization service, it's critical to let them know who these people are that you trust. Like at Bodis, for example, we're working on setting up not only an emergency contact, but a next of kin contact, so it's easy, so that the platforms are aware. These are all things you can do ahead of time. It doesn't take that much time. It does take some advanced thought and planning. The other critical thing I would say about whether to use a corporation versus a personal individual kind of setup is, if you're going to use a corporation, whether it's an LLC or C Corp or some other type of corporate form, you've got to look at your operating agreement or your articles of organization or what your other shareholders in your corporation have as kind of your estate plan, whether there's provisions in there for what happens at divorce, whether there's provisions in there for what happens at death, because I've seen some really messy business disputes. And sometimes, I think the real answer to that question is to determine how much faith do you have in your corporate organizational documents. Is it some one piece of paper that you filed 20 years ago that you really didn't think about? Maybe you've added on multiple partners and there is no real documentation of what to do. That's critical. Like if you're going to rely on your corporation to survive after your life and your domains are there, all that stuff's got to be in order, and you've got to really look at it and think about it. So what you want to do is, talk to the right people, find the Aries of the world, find these people that can help you develop a holistic estate planning strategy, not just from a legal point of view, but from a taxation point of view. You want to have the right CPAs and accountants, if necessary, tax attorney, especially if you've got multi-jurisdictional issues, if you keep your domains in an international corporation. Things can get complicated pretty quickly. But even if you've got a simple portfolio and you're just an individual investor, there's lots of low cost, easy to use tools. The internet's a great thing. You can learn a lot about this process, and just don't be afraid of it. There's a lot of jargon, right? But you can demystify it by just spending even a couple hours.
Questions for the panel? Yes, sir?
Yeah, questions for Mike. You mentioned,
Good.
yeah, so Mike mentioned the situation where he had, I believe it was the wife of the person that died, and then it was the brother, correct, what transferring the domain names. So how did you actually find out who was the rightful heir of these domains? Was it in the will, or because obviously both of them was family, so?
Yeah, so we obviously had to go and get a lot of documentation before we made any concrete decisions on ownership, and they included getting a death certificate, as morbid as that was, but also getting court documents to say that through the will they'll pass through to the wife.
And the domains were part of the will?
Yes, yeah, they're part of it.
down there. Wait for the mic. There are recordings and everybody would like to hear you.
Yeah, hi. Aryan, my question is to you. My name is Prakhar. And you mentioned about taking advantage of tax reductions, 7%. No. The one where you mentioned that when you bequeath your domain to someone, the valuation, is
Yes.
agreed upon. My question was there, how that valuation is determined.
How do you get the market valuation of the
Yes.
domain name?
How do you determine that valuation?
I-
Who certifies it, and how
So
do you?
I didn't read that tax directive. Does that talk about how you get market value? I mean, you get appraisals in the market, you get comps, but I'm
From
not sure.
whom? From whom?
Do you recommend that at death, that to get the step-up in basis, that the heir hires somebody who's going to value domain names for really high valuation?
Like,
All right,
government
all right.
certified.
Again, I'm not an expert on the tax code, but a couple of things. I don't know that I necessarily recommend you get valued at death. Maybe you wait until I'm not sure what the directives are, what the laws say. That if proper time to value an asset is at the time of death, yeah, I do recommend appraisals, and I think you should probably go to a few different sources. You want to get obviously a fair market valuation that's not going to be challenged. You're going to have to defend it if the IRS challenges it. So you want
it to be high.
You want it to be high because the higher it is, the lower the tax.
And the ideal time is at the time of death because that's when the step-up in basis occurs.
Exactly.
So you think that there might be valuation services that people know here. Michael, do you know valuators here that might value on the high side? They're always optimistic. Do you want to tell the folks out?
I mean, I think the question
And I
is-
agree, by the way, you want to hire multiple valuators so you can defend.
Yeah.
Who would those be?
Yeah, I mean, similar to real estate, if you're looking at selling a piece of property, somebody has died that has been transferred over. I mean, you can go to any number of recognized appraisal firms. I mean, in the domain space, GoDaddy has a service, Cdo has a service.
You recognize it, we recognize it, but the courts have to recognize it as well because there
Well,
are
the IRS, not necessarily the courts.
Sorry, the IRS, yes. There are if you search for domain appraisals, you'll find hundreds of companies online giving a range of appraisal,
Sure,
from $100,000 to $1 million.
I think if you use a nationally well-known established company in the industry like a reputable like Cdo or GoDaddy or
Do they have a conflict of interest though? Like they want the value to be lower so that they can sell it for you.
Well, that's only if you're hiring. I think. Well, listen. I'm sure you have to look at what they say in the appraisal, that it's objective. But I think if you get a couple, you're safe. You're not. The issue is going to come about when you sell the domain name and the valuation's there. In fact, as I think Michael mentioned, in terms of depreciation, is at that point that your valuation is going to come into play. Again, check with an account. In other words, you inherit these domain names and they're worth $1 million. Now you have 14 years to deduct that on an annual basis. The other question I wanted to ask you, Michael, by the way, regarding the depreciation, is I think when you sell the names, you have to recapture that depreciation.
Yeah, it's depreciation.
It's a little complicated.
Just like any asset, if you buy a tractor, the tax code now lets you take 100% depreciation year one. That was the adjustment that I mentioned earlier in the U.S. But a building is depreciated over 15 years. Okay, that means assuming you have gains, you can take that depreciation. When you do sell it, again in the U.S., that depreciation has to be recaptured. So you will be exposed to that at the sale if you take it along the way. That document, I think for anybody in this room, domainers, all of us, is well worth the read. It just opens your brain up in terms of how one government in particular, the UK I know is different, Canada treats them differently as well. It's just something to think about and look into based on where your citizenship is. The other thing I would add to your point there is looking at insurance. One of our clients has insurance. I know GoDaddy offers actually insurance specifically catering to portfolio owners. So there's ways to protect yourself in the instance of the unforeseen. If something happens, there are insurance mechanisms that you can look at there that would really, I think, only be warranted if you have a sizable portfolio. If you've had an issue in the past, you maybe foresee something in the future. So it's just like any other piece of property. I mean, you've got to have a way to protect yourself on it. You know, this hotel, the Omni, has insurance on this room. Doesn't mean they're going to have to use it, but it's just ways to protect your property and domains just because they're not tangible.
Question over there.
Hi, I'm Leonard Holmes. My domains are in single member LLC, which was recommended several years ago for domainers by a lot of lawyers. At this point, I want my daughter, I think, to have them when I die. So what's the best way to make it a more general question to deal with domains that are in a single member LLC to protect your estate? I could add my daughter and make a two-member LLC. That complicates taxes at the end of every year, but it's not that complicated.
So Manish, could you take a single member LLC and put it into a trust?
Yeah, exactly. Yeah. So I was going to ask you, besides the domains that are in the single member LLC, is there anything else held in the LLC?
No, it's just the domain business.
Yeah.
So could the member be a trust?
Exactly. So you could just assign the LLC to your daughter. In your trust, you could just say this LLC at my passing belongs to you, and then all of the assets will be given to her.
So you're recommending that the member now be his family trust, and then the trust provides at death, the daughter gets the company.
Exactly.
And the company has the domains.
Just the only note there would just make sure you have a trustee, someone who's administering the trust after you know, anybody can be a trustee, but, you know, have a bank, have someone reputable, an attorney, a fiduciary that can protect you, you know, without self-interest.
Ari, do you agree with that approach, or do you think there's a?
I agree with it, makes sense.
Any other questions? Over there.
This is
Well, you speak in the mic so everyone can hear you and we can record your voice.
not so much a question, but just looking for insight. Under the UDRP and federal law, there's a discrepancy, or there's a problem. Say this lovely person owns, or say there's a company called something really clutch like Victarvi, and say in 2000 I registered Victarvi.com. Now, some people in the UDRP are under the impression that if I die, that domain, the value, which might have been $1 million, is now, you know, anybody who purchases that domain is looking at a UDRP or getting that domain stripped, which is a point of public safety and, you know, should be self-evident. Your domain is alienable under Airfax in the Ninth Circuit. It's the creation date and the rights, the value carried through even in anonymous purchases. So the rights to resale, the rights to get you out of things like bad faith, carry through from the first date of who is creation through to anonymous purchases.
Transfers.
Yeah, so that's something that is going to be relevant if you're looking at a big portfolio. Somebody might say, well, that person is deceased and they've lost their predating registration.
Right. So, right. So what Francine's talking about is under the Uniform Domain Name Dispute Resolution Policy, a complaining trademark owner must prove three things. One is a domain name that's identical or confusingly similar, a trademark that's identically or confusingly similar to a domain name, that the owner of the domain name has no legitimate interest in that domain name, and that the domain name was registered and used in bad faith. So what under the UDRP, as Francine alluded to, let's say you registered a domain name in the year 2000 for some crazy name like, you know, ABC, this ABC company. And 10 years later, someone files a trademark for ABC company. And let's assume that it's worthy, it's a good enough name to challenge the other name, because it's not a unique word. I mean, it's not a common word. So, because the person registered the domain name prior to the existence of that trademark, under the UDRP established law now, that you could not possibly have registered a domain name in bad faith for a trademark that didn't even exist, and you registered it. You couldn't have had any bad faith. So Francine's saying is there are cases. There's a case in the Third Circuit out of Pennsylvania called Smedheine, and someone had registered this domain name, smedheine.com or something like that, and the person had registered it prior to the existence of a trademark. What happened was Smedheine, the name was originally owned personally, and then he changed the registration a few years later to a corporation. And the court held that changing of the name was a re-registration of the domain name, not just a renewal if the name changed, or a whole new creation date, which was now after filing of the trademark, and therefore they could argue that it's registered in bad faith. And that's what Francine's talking about. And what John Berryhill mentioned before, and the, John, I forget your name, sorry. No, this gentleman asked a question. Leonard Holmes mentioned about having the domain in an LLC. If the domain name's in an LLC and the person dies, it's still going to be in that same name of the LLC, so the corporate name doesn't change. So I think in that case, you had a stronger argument as to the good faith registration, because I don't know that you can put in your will that all the goodwill that I have with this and the registration rights I pass on. So having a continuity of that single name can prevent that issue of a re-registration causing the bad faith registration, because it postdates the later filed trademark from the original registration.
But do you agree that that issue should not exist as a point of public safety, for instance?
What do you mean by, what do you mean?
The issue should not exist. If you change the name of the registrant,
Yes.
the issue should not exist. The WHOIS creation date that predates the trademark took it out of a targeting framework. So if the WHOIS changes, the register changes, the right to predate the later trademark should carry through under the
Because
register.
the Ninth Circuit is different than the Third Circuit,
Yeah.
and there's nothing that we in this room can do about that. But I think that Ari identified what's a way to provide for that, as did John Berryhill. Put it into a company, and that company is the registrant. And then when death occurs, it's still the same company, no matter what circuit you're in or under the UDRP. It was registered before the trademark owner acquired any rights. There wasn't any so-called re-registration, which I agree seems to be a fallacy in certain circuits. And so by putting it into a company, you prevent all that.
Yeah, thanks for that question. That's one of the best questions. That's one of the most important tips here today in terms of continuity, because if you could have a great name, very valuable name, and somebody came over the trademark and they will come after you.
Yeah. The one thing I would add to that is privacy makes a great vehicle to protect against this as well. You can limit the amount of signals that are flagged when that transfer of ownership happens by having it under privacy. Obviously, the LLC shields you a little bit there, but if that's public and then that changes to a registrant that is different, they can argue an alternate use. I've been a part of a federal lawsuit and lost because of this exactly. So, the mark date and the original creation date, but an altered party use can all be argued depending on where you're at, different countries. So you have to have your portfolio set up in a way where once a UDRP comes in, once a federal lawsuit comes in, one of these gentlemen, an attorney, John, somebody is notified and it, almost autonomously takes care of itself. Because when you, who just spoke through that pretty articulately, are not here, who in your family is going to actually know, what to do, how to do it, who to contact? And really, the faster you get a situation to a lawyer, UDRP, federal lawsuit, the faster it's protected and combated. The last thing you want is your estate not to respond.
I'm not so much worried about myself. I'm worried about people in rural China who don't have the luxury of this first world complacency.
Well, companies are going to come after the cheapest way they can acquire a domain, and with no penalties on reverse domain name hijacking. There's pretty strong incentive to, if they can get a name for $2,500 UDRP filing, they're going to at least throw it at the wall.
But aren't we talking about, if we're talking about big ticket domain names, we're talking about portfolios at GoDaddy, and GoDaddy is in the Ninth Circuit, and Airfx has said that domains are alienable. So shouldn't this be a non-issue? Isn't this nailed home in the Airfx, which says, yes, they're alienable, there's nothing in the congressional minutes, certainly, they agree.
I think it always depends on who argues.
It's not an issue.
Yeah, it's what they argue and what you respond.
I think the right way to answer your question is, this is why litigation is horrible.
Yeah.
Absolutely.
Because stay away.
Because what ends up happening.
We're out of time. We're trying to be on the scope. Thank you for that.
Stay away from litigation.
And Michael and Mike and Ari, thank you for sharing your wisdom. I think everyone has guidance.
If you have any further questions for our moderator, Derek Newman, or the panelists, please chat with them later at the conference, or find them online using the NamesCon app. Please join me in giving Derek and the panelists another Texas-sized round of applause for their event today. The organizers of NamesCon welcome your feedback, so please take a moment to rate this session using the NamesCon app. And if you're tweeting about the conference,